Good morning, everybody, and welcome. This is our Spotlight webinar on arbitration, and particularly the enforcement of arbitration awards. This topic is the 8th in our series of webinars, and our webinar series places topical matters and leading industry lights under the spotlight. By way of introduction, I'm Damian James. I act as a delay and quantum expert in the UK, the Middle East and Africa, and I supplement my practice by acting as a dispute resolver in adjudications and arbitrations. I've acted as an arbitrator in commercial matters in the Middle East and Africa. I'm delighted to have with me today two leading lights in international construction law disputes. And firstly, I would like to introduce to you Ms. Sahana Jayakumar. Sahana is a barrister at Crown Office Chambers, and she specialises in commercial litigation and construction law. She advises and acts on both domestic and international disputes. She recently acted as junior counsel for the respondent in the Court of Appeal case of Abbey Healthcare and Simply Construct. And that was concerning the question of whether a collateral warranty could be considered a construction contract for the purposes of adjudication. Sahana has also had experience of working in the international arbitration team of a US law firm in Paris and spent 3 months in the DIFIC court in Dubai in 2018 on a scholarship awarded by the Honourable Society of the Inner Temple. As well as building up her practice at the bar, Sahana is currently completing an LLM in international dispute resolution at Queen Mary University of London. Secondly, and no means least, I have with me Mr. Alex Kelsall. Alex is a senior associate in the dispute resolution team within DWF's Doha office, having previously been based out of DWF's Manchester office in the UK. He advises on a wide range of disputes at all stages of proceedings and represents contractors, construction professionals and insurers in the UK and internationally. Alex has acted in arbitral proceedings for contractors and subcontractors, conducted under several arbitral institutions, as well as in ad hoc proceedings. He's also acted for construction professionals and their insurers in insurance policy coverage disputes, property damage and professional negligence claims in the courts of England and Wales. As I said, so today we look at arbitration and the challenges in enforcing awards, or in the alternative, challenging an award. This is another in our series of webinars, and both guests have experience of complex judicature in not only their own jurisdictions of practice, but also in international jurisdictions. Arbitration is currently challenged by the positive impact on the settlement of disputes that adjudication and mediation can have. And it may be that arbitration becomes less attractive when considered against the inexpensive alternative of mediation, the speedy alternative of adjudication, and the willingness of parties to simply resolve disputes without excessive costs. As parties to international arbitration become increasingly experienced and sophisticated, the enforcement of international arbitral awards may no longer be as quite as straightforward as we once thought it was. A party which has successfully obtained an international arbitral award may believe the hard work is done, but if the unsuccessful party does not voluntarily comply with the award, the winning party must take steps to enforce it, and those steps are becoming ever more complex and costly. They're often treated as an afterthought by parties in the council. The enforceability of arbitral awards matters. For failure to enforce an arbitral award will, in most cases, render that award of little or no value whatsoever. So you must enforce. Research shows that it's not all that bad. It shows that the vast majority of arbitral awards are complied with voluntarily. And the Queen Mary International Arbitration Survey, as long ago as 2008, said that 84% of participating councils indicated that in more than 76% of arbitration proceedings, the non-prevailing party voluntarily complied with the arbitral award. It'd be interesting now to get updates on that, and we'll get some feedback now from our speakers, just in terms of that trend. The good news for the efficacy and integrity of our international arbitration system as a whole, but what happens in those infrequent cases where enforcement is rightly or wrongly resisted? What if the challenges that arbitration has to face is a growing requirement in the enforcement of awards? Parties often require the ending of lengthy and often hostile dispute proceedings without entering the need for a further phase of conflict in enforcing awards, but they need to be aware of that, and that situation obviously manifests itself. Therefore, it is a reality that this process may continue. The construction industry has a heavy tradition of disputes, and improvements in dispute management for investors may allow greater confidence for future and continued investment. And we've seen third-party funding in place now for arbitrations. So it's important in respect of arbitrations, disputes being funded, that the enforcement can take place and that parties can succeed in their awards. The process of enforcement offers a resolution to unwilling parties, and this forms the basis of the questions that I want to put to our panellists. I'd ask that if you have any questions, you put them into our chat and we can pick up on them either as we go or at the end. Sahana, if I may start with you, thank you very much for joining us and braving the current UK heatwave.
Pleasure.
As a precursor to opening up our discussion and obviously drawing Alex into the discussion, maybe I can ask you to provide our audience with a brief examination, explanation, analysis of the distinction between recognition and enforcement, if that's possible.
Yeah, absolutely. So the New York Convention and other pieces of legislation, when we're talking about the enforcement of arbitration awards, often talk about recognition and enforcement of those awards. And I think it's just worth bearing in mind at the outset that those are two different things. So recognition is a step, which is exactly what it sounds like. It involves the court in a particular jurisdiction recognizing the effect of a foreign arbitration award. And this might be necessary in a case where, for example, say you were the defending party in an arbitration and the claim was dismissed against the claimant, so you were successful, but the claimant then tried to bring new proceedings or assert new facts before a court after the event. You could apply to recognize the arbitration award and cite the principle of res judicata to prevent those issues being relitigated. Or it might be that you want to use the matters that were decided in the arbitration award as part of a defensive set-off in a different claim. Enforcement involves taking an active step to realize the monetary value from the arbitration award. So in England and Wales, where the High Court agrees to enforce an arbitration award, it means that all of the available means of securing that sum that would have been available if you'd brought court proceedings in England are now available to that party. So for example, you can obtain charging orders or writs of control. And so it's possible to recognize an order without going through the step of enforcement. But if you're enforcing, you necessarily have to have the step of recognition first.
Oh, right. Very interesting. Very interesting. I think, we touch on international arbitrations here, and obviously the part of most practitioners' lives anyway, given the commercial development of the world between international companies. And not many days go by in the UK without talking about Brexit. When you talk about enforcement under the law of England and Wales, particularly, but when you put that into an international context, obviously definitely Europe, is it fair to say that Brexit has or it hasn't had an impact on enforcement when considering arbitration and court awards?
So in summary, the good news for arbitration practitioners is that Brexit hasn't had a significant impact on the enforceability of arbitration awards. But by contrast, it has made it a little bit harder to enforce court judgments coming from EU member states. This is because the UK has been a signatory to the New York Convention for a very long time. And the New York Convention, I think at last count now has 169 contracting states. Not all of them may have fully ratified it yet, but there are certainly 169 states that have signed up. That's the majority of UN member states. And the advantage of this is this homogenous means of enforcing arbitration awards across a number of countries. And the UK still gets the benefit of that as a contracting state. So if you bring a foreign judgment to the UK, you're still operating under the rules of the New York Convention. The problem with court judgments post-Brexit is that before Brexit and before the end of the transition period, England and Wales was subject to the Brussels recast regime, which set out a very streamlined procedure for determining jurisdiction and for the enforcement of civil and commercial awards in between EU member states. We are no longer part of that regulation as of 31st of December 2020, although it does still apply to any judgments predating that date, which a party may now seek to enforce. And so the options left are, firstly, the UK has tried to join the Lugano Convention of 2007, which is what underpins the Brussels recast regulation. And it's the convention which allows Norway, Iceland, and Switzerland, the EFTA states, to participate in a similar regime, even though they're not full EU members. But the European Commission last year refused the UK's request to accede to the Lugano Convention. So we're now left with a situation where, for European judgments, parties either have to rely on the 2005 Hague Convention, which is, I'm going to talk about that a little bit later in the context of a different case, but it's a little bit more narrow than the Brussels regulation and only applies if the judgment was obtained pursuant to an exclusive jurisdiction agreement. Or otherwise, for European judgments, it looks like they would have to be enforced using common law rules. And that involves an inquiry into whether it's a final judgment, whether it's a judgment for a specified sum of money. So there's no scope for enforcing injunctions, and an inquiry as to whether the original court under English law has had jurisdiction. So you can already tell that this is a much more complicated regime. There are a lot more hoops to jump through, a lot more potential defenses that can be raised when compared with the very narrow regime for enforcing arbitration awards under the New York Convention. So I would say post-Brexit, it is definitely much easier to enforce an arbitration award in England and Wales compared to a foreign judgment.
Okay, so I mean, as I understand it, and most people's default position would be the New York Convention and all the member states that are signed up, and particularly Article 5. Are we saying that that is still the most effective means of enforcing an award? Or does it have to be considered in the context of all the other issues that we have now? And if so, what is the procedure to be followed under the New York Convention?
So the New York Convention is the convention which governs it provides an exhaustive list of the circumstances in which parties that have signed up to the convention can refuse to enforce an arbitration award. So if you are a party trying to resist enforcement and you can't provide proof that your case falls within one of the categories in Article 5, you have no basis for resisting enforcement. And so that's the sense in which the New York Convention governs the rules around enforcement. It stops local courts being able to go beyond the matters that are set out in Article 5. Very briefly, the grounds under Article 5.1 are that the parties were under some kind of incapacity, or the agreement's not valid under the relevant law to which it was subjected. The party against whom the award is invoked wasn't given proper notice of the appointment of an arbitrator or of proceedings. The award might deal with something that is beyond the scope of submission to arbitration. The composition of the arbitral tribunal might not be, if it's not in agreement with not in accordance, with the agreement of the parties, or if the award has not yet become binding on the parties. And then there's Article 5.2, which provides that the court can refuse to enforce if the subject matter of the difference is not capable of settlement by arbitration. So if it's something that's normally excluded from the remit of arbitration, such as family proceedings, or the enforcement would be contrary to public policy. Public policy is one that it's not raised very often in the UK, but it can be. I know that in other parts of the world, it's a challenge that people would like to bring to see if they can resist the enforcement of an arbitration award. And so these provisions, this scope for refusing to enforce an arbitration award is codified in English law in the Arbitration Act 1996. And the procedure for enforcing the arbitration award is set out in Part 62 of the English Civil Procedure Rules. So there is a separate chapter specifically dealing with enforcement of arbitration awards. The rules are very prescriptive in terms of time limits and service requirements, and it's designed to be very fast and efficient. And the presumption is that the arbitration award will be enforced in England.
Okay, thank you very much. And it's interesting that you say that certain issues which almost seem like procedural or quite linear housekeeping issues, i.e., failing to give proper notice to the other side of the appointment of the arbitrator or the arbitration, sort of find themselves within the context of enforcement. It seems sort of quite a binary position that it's fairly obvious for two parties, really. So I do understand that and do appreciate the New York Convention deals with those issues, yet there are further issues in the ambit of it. Alex, if I can turn to you, and thanks very much for joining us today. Pleasure to have you with us, joining us from Qatar. You have a heavy focus in your practice, we've heard from your biography there, on dispute resolution in the Middle East, and I suspect that enforcing arbitration awards plays a heavy role in your work life. The arbitration law in Qatar that provides an arbitral award shall have the status of res judicata and shall be enforceable. Maybe you can just explain how that operates in the same context that Sahana has talked to the enforcement issues from the England and Welsh law.
Yeah, Damian, thanks. Just to say thank you, first of all, for having me. I've tuned in before to the webinar, so I hope I can do the series justice.
Thank you.
No legal pun intended. The Qatar arbitration law is a fairly recent development, actually. It was the Qatar law number 2 of 2017, which is the civil and commercial arbitration law, but I'll refer to it as the Qatar arbitration law, which governs the enforcement and award. It's largely based on the model law, the UN model law, with some slight variations. But it applies to arbitrations seated here in Qatar and to international commercial arbitrations as defined within the law seated elsewhere if the parties have agreed to submit to the Qatar arbitration law. I think it's worth mentioning also that Qatar is a signatory to the New York Convention. It's been so since 2003. The sort of context to the Qatar arbitration law, I think the reason it was passed essentially was the need to bring legislation in Qatar, and we'll talk about trends elsewhere in the region also, in line with modern day practices elsewhere. I think there's perhaps a recognition that there was a degree of uncertainty under the old law with rulings from the courts raising some eyebrows, which I'll touch on today. The effect of the Qatar arbitration law was to expressly repeal the old articles of the civil and commercial procedural law, and helpfully it refers to a number of articles, 190 to 210, and helpfully any other provision which contravenes the provisions of the new legislation. And so there's this little bit of ambiguity, but that never harmed anybody within the legal profession or certainly their pockets. As mentioned, the backdrop is that Qatar faced criticism following several rulings which set aside both domestic and foreign arbitral awards on public policy grounds, which sort of links to what Sahana was mentioning before. The rulings held that court-issued judgments here in Qatar, both domestic and even foreign arbitral awards, were required to be rendered in the name of His Highness the Emir, failing which the award could be challenged as a public policy violation. And the Qatar courts justified that at the time on the now repealed provisions of the civil and procedural law, the old law which I've mentioned. But since the issue of the issuance of the new law, there's no basis to maintain that requirement. And the added comfort there is that the Qatar Court of Appeal refused to set aside a Qatar arbitration award based on the argument the award was not issued in the name of the Emir in a recent judgment dated in July 2020. But the court also ruled that an application to challenge an award could only be made out under one of the exhaustive grounds set out in Article 33 of the new law, which mirrors the New York Convention. So although the court did not refer to the New York Convention, the grounds for setting aside the award mirror the grounds for refusing enforcement under Article 5. And so the Qatar courts have reaffirmed, it was necessary, their adherence to the New York Convention following the uncertainty and these sort of questionable judgments. Sorry, Jamie, I was just going to say, and there is a specific provision within the arbitration law which provides that an arbitral award shall indeed have the status of res judicata, the matter decided.
Okay, so enforcement is possible in Qatar, and is it possible regardless of the country in which the award was issued then?
Yes, that's true. The Article 34 1 also provides that an arbitral award shall be expressly provides it shall be enforceable regardless of the country in which the award is issued. I think the good news is enforcement is now possible. Well, it was possible, but is been reaffirmed in Qatar with the new law, with the above mentioned Court of Appeal ruling. There's now much greater certainty. But importantly, the new law appealed the ability to appeal awards on the basis of law and fact, and that's now been removed by the new law. Until the legislative reform, it was possible for the court to, at its discretion, review arbitral awards on the merit. And there is a case, I think from 2008, which effectively the court looked to annul the award rather than enforce it, having engaged in a full analysis of the tribunal's findings and the correctness of interpretation of the contract. But following the reforms, that's now a thing of the past, thankfully.
Okay, so the process of enforcement, what what sort of procedure would it be? And does it specifically differ from what we've discussed with Sahana already, or is it?
It's essentially mirroring Article 4 of the New York Convention. Provides for enforcement award should be submitting in writing to the competent court, copy of the arbitration agreement, a copy of the award or certified copy with a certified translation if the award is not in Arabic, unless the parties have agreed to alternative methods of enforcement. An application of enforcement, I think, has to be, should not be, is not able to be accepted. There's a time limit of 1 month for the submission of an application for setting aside under Article 34. But the reality is, though, that the administrative process of accepting an application for enforcement can take several months, the submission to be accepted by the competent court. And so if that is then subject to challenge, the delay can be significant.
Okay, and that enforcement process that you talk about, I mean, for many people, they'll think that it's common throughout the Middle East. Is the process in Qatar different from that, say, in the United Arab Emirates, or are they all becoming aligned? I
mean, there is a trend and a move to alignment. The UAE, I think recently, I think in 2018, overhauled its arbitration law, again, largely following the model law. So the enforcement process is fairly similar. Again, just on the model law, we've seen that now adopted by over 100 jurisdictions, in prominent jurisdictions, as well as regionally. It's now been adopted in Bahrain, the Kingdom of Saudi Arabia, Oman, I think reflecting the international nature, flexibility, and a trend and a move towards the adaptability and the adoption of the model law. There is a notable absence in the UAE arbitration law regarding the application of the new law to the seats of the Dubai International Financial Centre and the Abu Dhabi Global Market. And so those two free zones, I think, continue to be governed by the relevant free zones arbitration law and regulations, which I suppose provides an added dynamic and complexity there, which we do see in the context of these free zones that are sort of popping up. They seem to be popular.
Okay, excellent. Thanks very much. That's really helpful. Sahana, if I may come back to you now. When we discussed international arbitration awards and we talked England and Wales, you did touch on the subject of public policy. It may be a cause for resisting enforcement. Where do you think we are, or where is the law at the moment on this type of issue in light of recent developments?
So in England and Wales, and those listening will have to obviously excuse that my specialism is focused particularly on England and Wales because enforcement is a jurisdiction specific issue. So this is going to vary depending on where you're going to seek to enforce your award. But to the extent that England and Wales has any influence on any other jurisdictions from the decisions of the commercial court, I think it's helpful to have a look at the status of public policy challenges here. And I think that recently there haven't been a large number of public policy challenges to arbitration awards at the stage of enforcing a foreign award. There is a recent case from 2020, it's Alexander Brothers and Alstom's Transport, which was heard by Mrs. Justice Cockerill, who's now in charge of the Commercial Court in London. And the argument put forward was that enforcement of the arbitral award, the facts are quite complicated, but in brief, the enforcement of the arbitral award was resisted on the basis that the defendant alleged that the consultancy agreements which formed the underlying contracts in the arbitration were procured by bribing Chinese officials by the claimant, and that therefore there was a public policy reason to set aside the award that the claimants had obtained in arbitration. Mrs. Justice Cockerill gave a detailed judgment because she acknowledged that the law was not particularly clear on the question of public policy and how that challenge was to be considered by the courts when it was brought before them. And her judgment's very interesting because she makes the point, firstly, that not only is there, when we talk about public policy, people normally think about the issues that were raised by the defendant here. So setting aside awards which are tainted by perjury or bribery or corruption. But she also expressly says in her award that in England and Wales, there is a public policy in favour of enforcing arbitration awards. So that is a relevant factor that is balanced against any arguments that might be brought to try and resist the enforcement of that award. She pointed out, she went through a series of cases and pointed out that even in cases of fraud and perjury, you have to show that there is a strong prima facie case. You can't just simply assert that there's something that's a bit dodgy that's gone on in relation to the arbitration award. There has to be a strong prima facie case, and the evidence, you have to show that the evidence couldn't have been adduced in the arbitration hearing or before the court with supervisory jurisdiction. And that second point, I think, it's very significant because it reminds us that when we're talking about the enforcement of foreign awards, we are at a stage where any arguments that could have been raised, that the parties have had two separate opportunities to raise these kind of arguments, firstly before the tribunal itself, and secondly then before the courts where the arbitration is seated in order to try and get the award set aside. So if we are now at the final stage of enforcing the award and trying to realise that monetary value, if those arguments could have been raised but weren't, or were not successful at earlier stages, it's very unlikely, even if you think that there is a strong public policy bent and some real concerns underlying your arguments, it's unlikely that the court is going to set aside to refuse enforcement on the basis of those arguments at this final stage. She also made clear in her judgment that there is a public policy argument in favour of finality of disputes. So again, that mitigates against the likelihood that the court at the enforcement stage, the last stage on the road to realising the monetary value of an arbitration award, it is going to go against the decisions made by an earlier tribunal, or where applicable by the court of the seat of the arbitration. And she also mentioned that the court will nearly always refuse to revisit an issue if it's been decided by a foreign tribunal. This is because great importance is given to respecting the decision of international tribunals. And she mentions this specifically in the context of commercial arbitrations, which tend to be administered by reputable institutions like the ICC or the LCIA. So where there are generally rigorous appointment procedures for approving arbitrators, and arbitrators are well aware of the duties that are on them, and these are often experienced arbitrators, if they have decided a point, the English Commercial Court has made clear that it will its respect for arbitration extends to a respect for the decision making of the arbitral tribunal itself. But the facts of the case were significant also because the allegation of bribery that was put forward, it was the first time at the enforcement stage that bribery specifically had been alleged. Mrs. Justice Cockerell noted that at prior stages there had been vague allegations of corruption or wrongdoing. And so it reinforced finally the point that if you're going to make these kind of public policy arguments, you have to make them strongly and you have to make them clearly, which I know is not necessarily the same as in other jurisdictions around the world.
Okay, excellent. Thank you very much. Very informative. I mean, obviously we touch on there the finality of arbitration decisions, and obviously in the sort of often a precursor to arbitrations are adjudications. Now we know that in terms of the UK, the statute of the 1996 Act prevails, and we all consistently reinforce the principle of pay now, argue later. What does the 1996 Act mean for international parties who wish to enforce an adjudication decision? How do those principles stem down?
So the significance of the 1996 Act is, and I'm not sure the background of the attendees that we've got today, so I'll assume for ease a sort of lowish level of knowledge. I think the significance that is sometimes lost on international parties is that the 1996 Act, it imposes a mandatory regime for adjudication and payment mechanisms in construction contracts, but it relates to contracts that are performed in England, Wales, or Scotland. And Section 104 explicitly makes clear that this is irrespective of whether the governing law of the contract is English law or Scottish law. So if you are an international contractor that is doing work in the UK, even if your contract is governed by by the law of a different country, you can still be subject to the adjudication regime if your contract falls within the definition of a construction contract under the Act. So this was sort of highlighted in the case that you've mentioned in the preview for this webinar, the Mutakus case. So this was a High Court case from 2020 where a party sought to resist the enforcement of an adjudication decision on two bases. Firstly, that the construction contract had an exclusive jurisdiction clause in favour of the courts of Paris. And secondly, that that was the basis of the challenge, pardon me, the defence had two parts to it. So they were trying to resist enforcement on the basis that the contract was governed by Italian law, it had an exclusive jurisdiction clause in favour of Paris, and therefore they felt they shouldn't have to pay the award, and they should be able to resist enforcement before the courts of England and Wales, the courts to which they argued they had not granted jurisdiction. In response, they relied on principles under the Hague Convention, which we discussed earlier, which says that which enshrines respect for exclusive jurisdiction agreements that have been concluded between different parties. But in response, the defendants pointed out that under Article 7 of the Hague Convention, the convention doesn't cover interim remedies. And so the discussion was firstly whether it was manifestly contrary to public policy to enforce the adjudicator's decision in what the defendant argued, was a breach of the exclusive jurisdiction agreement between the parties. And secondly, whether the adjudication was actually an interim remedy and therefore not covered by the Hague Convention. The court found that it was necessary to respect the exclusive jurisdiction agreement. However, the court pointed out that the adjudication award was an interim remedy because as you said, the principle is pay now, argue later. It is open to the parties in adjudication cases to bring court proceedings or to commence arbitration in order to determine the true legal position. And so for that reason, the award was enforced and it was held that the Hague Convention did not apply. I think that the case is also very interesting because the judge in that case also discusses the case of MBE and Honeywell, which is a case which emphasizes the principle that adjudication awards have to be complied with, and it is not possible to apply for a stay of the enforcement of an adjudication award on the basis of an arbitration agreement. The pay now, argue later principle means exactly that. The adjudication award at first instance is enforceable, and even if parties have an agreement to arbitrate, and even if that's completely removed from England and Wales, if the construction project took part in England, Wales, or Scotland, and an adjudication award is made against you, you have to pay that award, and there will not be a stay of proceedings to enforce payment of that award pending the resolution by arbitration, because then that would fly in the face of the underlying purpose of the adjudication regime.
Okay, so I mean, obviously, I've seen in South Africa and on other jurisdictions that the principle of pay now, argue later is being generally accepted and reinforced in the courts, unless there's something totally obvious or which resists such an award being enforced. We've seen just recently in the South African courts that Qualelect and Bello, and the court endorsed the approach in terms of that principle. In terms of enforcement proceedings, aren't we seeing any new issues arising, any new novel attempts to prevent enforcement, or is it very much underlined by the pay now, argue later principle still?
I think that the pay now, argue later principles are becoming very much cemented in English law and certainly in the commercial courts and the TCC. We have had recently, since Moticus, we've had guidance from the Supreme Court on adjudication in the case of Bresco and Lonsdale. This was a case which related to the question of whether an insolvent party via its administrators or liquidators could commence adjudication proceedings. And the Supreme Court held that in principle this was possible. But in the course of his judgment, Lord Briggs carried out a detailed overview of the adjudication regime and how it works. And there's some very useful points in his judgment relating to the state of the regime and the status of the pay now, argue later principle, because he points out that the statistics seem to show that in adjudication, most adjudication decisions achieve a de facto final resolution of the underlying dispute. So even though parties can go and litigate later on or take the matter to arbitration, they tend to take the decision of the adjudicator as effectively the final point, or they use it as a point from which to settle. And it's perhaps not relatively very common for parties to actually go and spend the money and litigate or arbitrate to get a final resolution. In terms of challenges to adjudication awards, I think the scope, in light of that dictum and in light of the principle, is similar to the approach that the court takes with arbitration awards. Really, the pro-enforcement stance that they take has also transferred over into adjudication. And so I think that the number of challenges that you can bring that are actually going to succeed is narrowing, and parties, perhaps if they're going to challenge enforcement of adjudication awards, do have to be a bit more creative. And for example, there was a Court of Appeal decision in 2005 where it's stated pretty strongly by Lord Justice Chadwick that the assumption is adjudication awards will be enforced and that payment will be made. And unless, if somebody seeks to challenge an adjudicator's decision on the ground of an excess of jurisdiction or breaching the rules of natural justice, and unless this case, if a party is going to make that challenge, unless it is very obvious, this course of action is likely to lead to substantial waste of time and expense. So I think that gives you a real indication of where the courts stand. Having said that, there are obviously, I think the challenges that are likely to be successful are going to be those that are very specific to the facts of the case. There was one that I just wanted to mention because I think it's very interesting and quite unusual, in which enforcement was successfully resisted. It was a High Court case, Marbank and G&D from last October. I actually participated in the adjudication stage, but one of my colleagues in chambers acted at the enforcement stage. And essentially enforcement was refused because on the facts, the claiming party had commenced proceedings in court and its claim had been struck out. I think there might have been multiple strikeouts, but their claim had been struck out in the county court and relief from sanctions refused. They then commenced adjudication, and the adjudicator made an award in their favor. But the entire time, my client, the defending party, had objected to jurisdiction or objected on the grounds of abusive process because there'd been a previous strikeout. And when it got to enforcement, the High Court agreed that actually it was an abusive process to try and enforce an adjudicator's decision in court in circumstances where the county court had already struck out the claim and refused relief from sanctions. The judge made the point that if they were trying to relitigate, they wouldn't be able to have a second bite at the cherry. So there was no reason why the adjudication procedure should allow them a way around this well-established rule. So I just thought that's a useful example of a resistance of enforcement on very, very unusual and specific facts to the case. And those are the kinds of challenges, rather than broad brush arguments about jurisdiction, cut and paste, from same pleadings. If you want to challenge the enforcement of an adjudication award, you have to be specific to the facts of the case before you.
Yeah, absolutely. Thank you very much. Alex, if I can return to you and just keeping with that then, obviously working across a number of jurisdictions, experience here in the UK and in the Middle East. From your perspective, what are the two-part question, I guess, what are the biggest challenges to a successful enforcement? Or in simpler terms, I guess the second part is, where can enforcement go wrong?
I think it has to be remembered that Article 5 of the Convention provides an exhaustive list, and as Sahana referred to before, it effectively provides the ceiling for resisting enforcement. I think also we have to bear in mind that recognition and enforcement award may be refused only if one of the exceptions applies. So the list of possible grounds on which a party may resist enforcement is narrow, but also is sort of associated with the most egregious irregularities for the basis of the defence to enforcement. The fact that that provision provides enforcement may be rather than shall be refused on the specified grounds is consistent with the pro-enforcement approach and bias of, or the pro-enforcement bias is often termed, of the Convention. So nothing in the Convention actually requires a contracting state to deny enforcement award. Instead, the court may overrule the defence to enforcement and give effect to an award even if one of the objections has been established. And we've even seen enforcement of awards that have been annulled at the seat of arbitration, I think recently in the UK. I think to give an example of where enforcement can go wrong in a way that it perhaps might surprise viewers that the award was held unenforceable is the Federal Australian Court's decision in Energy City, Qatar Holding Company and Hub Street, in which ECQ sought to enforce an Qatari arbitral award rendered pursuant to an arbitration clause in a contract between ECQ and Hub for the supply and installation of street lighting and furniture in Energy City, which is here in Qatar. The contract and the conduct of the validity of arbitration were governed by Qatar law, and ECQ commenced arbitral proceedings under the contract to recover the advance payment. Whilst the arbitration clause required ECQ to send a notice to Hub giving Hub 45 days to appoint one member of the arbitral tribunal, ECQ instead filed a statement of claim in the Qatari plenary court of first instance, seeking orders that the court appoint an arbitral tribunal of 3 members, including an arbitrator nominated by ECQ. ECQ sent a notice of court proceedings to Hub, and once the tribunal was established, they sent 6 notices in English to Hub about the conduct of the arbitration. Despite the notices, Hub didn't participate in the arbitration, and the tribunal adjourned the proceedings on 3 occasions due to Hub's failure to attend. As there was never any appearance by Hub in the proceedings, the tribunal proceeded to determine the dispute and make their award. And then enforcement proceedings followed in Australia. Hub challenged the enforcement of the award on a number of grounds under Australia's International Arbitration Act 1974, most of which were dismissed. But the primary issue for consideration, certainly by the Court of Appeal, was whether the award should not be enforced because the tribunal was not constituted in accordance with the contract. On appeal, the court overturned the first instance decision, holding that the award could not be enforced. The tribunal was not constituted in accordance with the parties' arbitral agreement. It lacked the requisite authority to determine the dispute and to grant relief. And I think it's worth just quoting the appeal court. It said that any exercise of jurisdiction of the Qatari court to appoint arbitrators to the dispute of the parties rested on the parties' agreement. And since what they agreed was not followed, the basis for the exercise of that jurisdiction was lacking. The failure goes to the very heart of the decision that ECQ would have this court recognise. And on that basis, the appeal court overturned the first instance decision and the proceedings were dismissed. But I think that decision really highlights the importance of strict compliance with what might seem like a minor procedural point in the context of the arbitration agreement, particularly in regions where local courts may be prepared to take a flexible approach to arbitration procedure. And the decision serves as a helpful reminder that despite the fact most courts most countries are signatories to the New York Convention, there's a reluctance to refuse and there's a reluctance to refuse enforcement of arbitral awards. Their non-compliance with the terms of the arbitration agreement can run the risk of creating difficulties much later down the line in the subsequent enforcement proceedings.
Yeah, thank you. Sahana talks about creative approaches there, which is always interesting to hear from someone working in the legal fraternity. Do you think, in terms of enforcement of international arbitration awards, we'll see more creative approaches? If so, what do you think they would be, or do you think based on what you've just said there, which obviously seemed a very supportive framework, that the arbitration process is currently suitably well placed to address any issues that it may face. So I suppose, you know, if you were going to give any insight to the audience today, it's, you know, what do you expect for the future creative approaches to enforcement of international awards?
Well, I think a tough one. I think just looking at it from Qatar's perspective, in terms of following controversial rulings, and I think looking at maybe from a more regional perspective as well, looking at the UAE and the adoption of a model law by other sort of states in the region. The region's come a long way, and arbitration has come a long way in the region, and so setting aside awards before the Qatari courts and elsewhere in the region is becoming a more difficult threshold to meet. And I think that's a recognition of countries, wanting to encourage investment and adopt arbitration as a means of dispute resolution. I think it just signals a more arbitration-friendly jurisdictions within the region. I think in terms of the future, we can certainly sort of see improvements as more international arbitration systems pass modern legislation that's consistent with the model law, with international best practice, which provides greater guidance on enforcement and the ratification of international conventions, and also strengthening the capability and the knowledge of the judiciary in such countries to understand the enforcement of arbitral awards. And I think we're again seeing that through the investment in local arbitration centres here and in Dubai and elsewhere.
Okay, so the future looks fairly solid then in respect of enforcement, and challenges will be sustained in the context of the existing process and the development of the existing process. But maybe Sahana, I'll come back to you now, and then it's always an interesting topic with you being at the forefront of certain issues. Obviously, the world is a changing place at the moment, and costs are at an issue in terms of normal and regular households, and definitely in the business world, money seems to be a little bit compressed in certain industries. The question I want to ask you is, are you seeing client briefs raising challenges to arbitration and adjudication awards and decisions, both in the UK and internationally? But maybe I ought to caveat that by saying, are you seeing them but advising not to make a challenge because the law is good in that respect? I mean, what are you seeing at Chambers at the moment?
I think in the commercial court, it's in terms of arbitration, the court business, it's more common, it's certainly more common to see challenges under sections 66, 67, 68. So that's challenging the substantive jurisdiction of the tribunal, or for 67 and 68, these are challenges where London is the seat of the arbitration. A lot of the arbitration work I tend to do is London seated. So it might be, as I said, when we're talking about those different stages, when we're working towards the final resolution and the final realization of money from the arbitral award, it might be slightly more common for the courts in London to deal with challenges as the curial court for the relevant seat, compared to challenges to the enforcement of foreign awards. In relation to adjudication, I think that because the process is so speedy, I mean, for those who aren't aware, generally the accepted timeline is that from referral of the notice, once the adjudicator has been appointed and a referral has been submitted by the claiming party, a decision should be reached within 28 days. It is very, very rapid. And I believe the TCC guide says that the enforcement stage, the enforcement hearing should generally be around 28 days from the date of the decision. So I'm not sure how strictly they're able to keep to that target in all cases. But because it's so rapid, and because there is this priority over speed rather than potentially thorough legal analysis, because there is this opportunity to resolve it later, there are parties who will always try and roll the dice at the enforcement stage and maybe try and bear the cost risk to try and put forward what my buzzword creative arguments to see what they can do to resist payment at this stage. But I think the tone of the case law shows that it is clearly better for the parties to consider themselves bound to pay and to try and minimize their costs at the adjudication stage in order to save them and put their efforts into litigating or arbitrating later on to have the matter fully and finally resolved.
Thank you. Alex, maybe come back to you. Similar question, put you under the spotlight, so to speak, but maybe a different version. Are you seeing issues in awards? And this, you answer this any way you'd like, honestly. Any issues in awards that you think can be challenged, and are you advising clients to challenge arbitration awards?
I think the trend here is to challenge awards, and I think that goes to the fact that challenges to awards are par for the course, not necessarily in the belief that the challenge may be successful, but that it may be used to create effectively a bargaining position and a bargaining chip to reach a reduced settlement, rather than get wrapped up in enforcement proceedings before the court for, say, another year, because of the speed with which enforcement proceedings proceed over here. After you've, say, waited 2 years for the arbitrary proceedings to conclude. So there is I think there is a trend for changes to enforcement to just be taken, and we've seen various examples of that. Public policy grounds, I mentioned sort of the previous cases, but there is a possible lacuna in the law here that parties must be represented by lawyers registered in the Qatar Register of Lawyers, and so we see others in the practicing here adopt a cautious approach, ensuring that local counsel is engaged, attends hearings, and provides representation to meet the requirements and the provisions of the Law Practice Act advocacy law. But it may be argued that and it has been argued that where local counsel has not been engaged, that is a violation on public policy grounds, and it can be used as an argument to set aside. But again, I think these sorts of arguments, and similarly challenges on grounds of awards of interest, whereas interest is prohibited under principles of Sharia law, which are considered, again, a public policy violation. I think the courts in Qatar, there's a shift towards an acceptance of the approach towards interest, but these sorts of public policy grounds and others are effectively used to provide you with, as I say, that sort of further negotiation stage.
So, I mean, obviously, as a lawyer, you mentioned there takes you into a further stage, a negotiation stage. So clearly, there's a financial motivation behind certain aspects of it, and that might be born out of ability to pay or time to pay. So on the basis that a challenge is brought out of financial motivation, either to improve or better the award that's been brought against a party, if the enforcing party decides that they don't want to be party to those financial motivated issues, how long would it normally take before somebody would recover their full award plus the interest and any costs?
Well, it's difficult in so far as it can take anything from, I would say, 2 months to a year or longer. The courts are, notwithstanding the new arbitration law, the courts are sort of slow to act, and it takes time to recover effectively. I mean,
obviously, yeah, and that obviously almost flies in the face of justice being done and being seen to be done, doesn't it? Really, I mean, Sahana, I can bring you in on this as well because we're coming to the end of our session. What improvements do you both think that could be made to the enforcement process to avoid this, further? It's not a further bite at the cherry procedurally or substantively or in respect to curial law. It's a further bite at the cherry based on financial motivation and the fact that if you don't take this, we won't be able to pay the full amount to you. What do you think can be done in the current processes, the current arbitral institutions, the current courts that you're both familiar with, to improve that process? Bear in mind the adjudication process from a decision being made can be enforced within 28 to 56 days. I mean, arbitration is taking possibly 12 months, like Alex has suggested there. What can be done to change that and improve that process?
I think that unfortunately, I think sort of Alex briefly mentioned this as a bit of a joke earlier, but when lawyers are involved, they will find ways of generating arguments if they need to. I sort of think about, for example, slightly off the topic of arbitration, but within the courts in the UK, the pilots that we've got for disclosure, which were introduced a few years ago, which were meant to make things a lot more simple and to narrow the areas of dispute for disclosure of documents in court proceedings. Lawyers have still found a way to pick holes in it and to create problems, and the costs and case management conferences that are meant to be quick tend to be dragged on. I think that in England and Wales, the strong indications that there is a presumption in favor of enforcing arbitration awards is probably is very helpful, because it does inform parties' decisions. If parties want to rack up costs and waste time and be subject to cost orders afterwards, then that is a risk that they're always going to want to take. But if the court, given that the court is making ever clearer pronouncements in favor of arbitration, whether that's in terms of respecting arbitration agreements or respecting the appointments of arbitrators, refusing to accept jurisdiction if there's a Section 9 application brought, or in favor of enforcing awards, if a party then brings a case which flies in the face of established principles before the court, they're going to suffer with costs later on, and that's possibly the strongest deterrent at the moment that the court can put down.
Okay, Alex, any thoughts on it?
Well, I think as I say, as we've seen, sort of, I want to say a cultural shift, but a shift and an acceptance of arbitration in the region, in the Middle East. I think that there still needs time for those new arbitration laws really to embed, and for the courts to become familiar with the practice of enforcement under the new regimes. So I think there will be a tendency for the UK and US have traditionally been seen as pro-enforcement, and therefore sort of challenging for challenging's sake isn't such a sort of a trend. And I think we will probably see that start to disappear in the Middle East also, as the courts become familiar with the new laws, and because of that shift towards wanting to recognise and use arbitration more frequently.
Are the courts, I mean, obviously the adjudication process in the UK has the technology court, which allows decisions at adjudication to almost be enforced within 28 to 56 days. Should there be a drive for the same expediency within international courts who are dealing with arbitration enforcements? Is that where this should go? Or should it just get caught in the normal commercial court and take 12 months? I mean, if it could be done expediently, then more confidence will be brought about from arbitration and recovering your money within the correct period of the award. Is that something that could be achieved, do you think, in our lifetime, or do you think that's a long, long way away?
I think that there could be, there's always scope to improve these things. With arbitration, I think it's a bit more complicated because there's a greater scope of disputes that can be referred to arbitration, and perhaps like slightly more complex factual matters. Adjudication, of course, applies to construction contracts, so it's relatively speaking a narrower class of cases, and it's the same fact patterns that are going to come up before the TCC. I think one thing that could be, from my time in the DIFC, I spent time in the DIFC courts, and as Alex mentioned, there are a lot more of these kind of offshore hubs that are cropping up. You've got the DIFC, you've got Abu Dhabi, and then in Astana as well. it would be interesting to see what the English Commercial Court can learn from the processes there, because from my memory, there was a real focus in these courts of condensing the procedural rules, moving away from the chunky volumes of civil procedure rules that are used in the English High Court, and trying to make everything, every aspect of court, the court user experience much more streamlined. So one thing that could be perhaps interesting is to see that as these courts grow and develop in these regions, is there anything that the High Court can learn from how they operate when they're operating effectively from a standing start, to improve their own processes and to take away from that.
Thank you, Sahana. Alex, anything to add before we close?
I was just thinking in the context of how recent decisions, and I was just thinking about the arbitrator's impartiality and the Chubb-Halliburton decision, and how that actually, the Supreme Court's decision there might force like the leading arbitral institutions to issue further guidance by way of amendment to their rules to address arbitrators' duty of disclosure, to prevent such challenges sort of going forward. And those sorts of changes will help to reduce these these sort of unmerited challenges to awards, because the guidance can be clearer. And as and Sahana just mentioned about the free zones, it's about different jurisdictions, different institutions looking at best practice and looking at ways to tighten their guidance, tighten their laws, to ensure that we don't see frivolous challenges to enforcement.
Okay, thank you very much. I think we've reached the end of our time. I don't think we have any particular questions from the audience there, and I think I brought a few more questions in, which extended the length of our discussion. But suffice to say, it's been an absolute pleasure to have you both with me today. Thank you very much, Sahana. Thank you very much, Alex. Thank you very much for your time. I know your time is valuable, but obviously your opinions and your narratives and your discussions today have been invaluable to myself and to the rest of the audience. So thank you very much for that. This spotlight will be available on our YouTube site, and that can be found via our website, along with our previous spotlights. So it leaves me to say thank you very much to our panel today, and thank you to the audience. And I look forward to seeing you again at our next spotlight, which should be around October. Thank you very much.
Thank you, Damian.
Thank you.
Cheers, Alex.